you evicted from that location?
No, no.
Okay.
We were already to golf side.
Okay.
We were already getting out of there.
Who is we? Ellen wants me to take Bellinger in.
Did you hear that? All the way?
Yeah, I did. I heard that all the way. I get good ear.
Bring him up after this.
Court does call the case, People versus Franklin Melton.
And Assistant Public Defender Jay Bellinger, on behalf of Mr. Melton, who approaches. Melton, can you please state your name for the record?
Franklin Joseph Milton.
Your Honor, we are asking for an adjournment in this matter as well. The adjournment is as a result of, we sent a request for consideration for an offer to the prosecutor. We did initiate the negotiations. We're just still working on those. So I think a short adjournment would do it. Yeah, if the court so allows.
Oh, are you done?
Yes.
Any response from the people? Probable cause conference, June 13, 2024, 9 a.m. Bond continued.
Your Honor, if I may briefly.
That's where we were going. Go ahead.
I know. It's my understanding that Mr. Melton has CMH Act Services set up. Tom Kloss is the individual who's assigned to the case to his matter. He has a set up keys and knows where Mr. Melton's going to be staying. Should he get out, an offer requesting home confinement was also sent to the prosecutor for her consideration as well to see about a stipulation to the request. And so I would just be asking for your consideration as well. It's my understanding that Ms. Tenha is leaving it to the discretion of the court.
Where would he be?
Up on golf side. I have a 2-bedroom up there, sir. Tom from Community Mental Health has the key and is ready for everything for home.
When did that happen?
I'd have to pull up the,
Well, no, when,
I'm sorry.
that's not the address that we have.
I think, Your Honor, that might be the address he set up with Mr. Kloss. I don't know what address that he may have given for arraignment purposes. And I'm certain that that was likely different. Is that correct?
Yeah.
Okay.
Yeah, that was a different one. The person's unable to do anything, but Tom Klaus has the key and has everything ready for home confinement.
So my understanding, and maybe Mr. Bellinger can correct me if I'm wrong, this is my understanding speaking with him this morning, that this individual from CMH has confirmed that he has an apartment with a key for Mr. Melton. And that if he were to be allowed to home confinement, that's where he would go. CMH not only would have that address, but would be providing him services there. For the record, I don't have any documents or anything. I'm relying on representation by Mr. Bellinger that he has that information.
Oh, because I thought the person might be able to let me stay.
Okay. Understood. Your Honor, to clarify further, during the arraignment, he gave a different address to an individual who he assumed would allow him to stay and reside with that individual. That address that he's now given to Mr. Kloss for purposes of home confinement is an address that he's had for a place that he's had for a year now. So it's his own place.
Yeah, and
On golf side?
I'm sorry,
On golf.
on golf side, sir.
He's had that for a year?
He's had his own residence for a year. I don't know what the circumstances were at arraignment to the extent that he couldn't go back there or why he.
What is the Arbondale address?
The Arbondale is where I used to live. I lived there for, I had the address for 22 years. Never missed rent.
Did this get you? Did being in custody get you evicted from that location?
No, no.
Okay.
We were already to golf side.
Okay.
We were already getting out of there.
Who is we?
Tom Klaus was and we were moving out of there
So was Tom helping you do that through CMH?
through CMH.
Okay.
Yeah, it gets into this whole thing that it
Okay.
does. Yeah.
Your Honor, if I may, just briefly.
Yes, please.
So what we would want for Mr. Melton is to receive CMH service.
Yes.
Correct.
If he's able to do so in a way that keeps the community safe and keeps him out of trouble, we are all for that. We understand that we always want to strive for the least restrictive means we can do that. If there is a CMH person who has indicated to Mr. Bellinger that he has a key and everything is set up for home confinement, we will leave it to the court's discretion. What I failed to ask Mr. Bellinger, and I apologize, is whether he's had direct contact with the CMH person, or if this is all relying on Mr. Melton's explanation, because there obviously have been some issues with that in the past. So if we can kind of clarify on the record that Mr. Bellinger has been in direct contact with Mr. Klaus with CMH and has received information from him that Mr. Klaus has a key to an apartment that is ready, that would be appropriate for home confinement. We will leave it to the court's discretion.
Your Honor, it's my understanding that Ms. Baltima from our, the social worker from our office has had and been working with him and has had that direct contact. I have not personally had the direct contact, however, someone from my office has.
Okay, so here's what I'm going to suggest. I'm going to, at this time, deny your request.
Okay.
However, I'd suggest that you work with the prosecutor's office, get that information to them. You've heard their position. And I
Certainly.
think that's an appropriate position, that if there's some place that's safe that is appropriate for home confinement, that's fine. But right now, I don't have anything concrete that says he has an apartment on Gulf Side, and there's a lot of them there.
Understood.
All right.
Thank you, Your Honor.
Thank you.
Okay. Okay. Mhm. I'm gonna work on it as soon as possible.
Okay, thank you.
Okay. Thank you, Your Honor.
Thank you. Just Edwards.
This is your recall from any corrections.
Court does call the case People versus Luke Edwards.
Vaughn Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Edwards. Mr. Edwards is approaching the podium. State your name for the record, please.
Good if you want.
Okay. State your name.
Luke Edwards Jr.
Today is the date and time set.
Excuse me. I address the court, John. Can I address the court, John?
I'd advise against it. I've advised him to speak to me first.
If you want to address the court, your counsel has advised you that it may not be possible for you to do so, so.
I and my attorney don't see things the same way. So I would, right now, like opportunity to get another attorney.
Okay, and how do you intend upon doing that?
I mean, I'm hard of hearing. Could you put those on for me? I was at work.
Can you hear me now?
Yes, sir.
So with reference to an attorney, how are you intending upon doing that?
I'm going to ask to have another one appointed to me.
Well, it doesn't quite work that way.
Okay.
And this is news to me. I did see Mr. Edwards yesterday and there seemed to be no issue.
So you've actually talked to Mr. Brown?
In this whole procedure, I may have talked to Mr. Brown, what, maybe about an hour, 15 minutes here, 15 minutes there, 5 minutes here and 5 minutes there.
Okay.
This is my first time ever being in court in any type of way.
Okay. So what am I supposed to take from you?
That I'm not satisfied with my attorney. And I think I should have
So what are you not satisfied with?
our communication, my understanding of anything.
Have you been listening to him?
Yes, I have.
You have?
I've been listening to him.
And you're telling me Mr. Brown hasn't properly communicated to you or with you? Because if you're going to say that, I don't believe it for a minute. He's one of the finest attorneys Washington County has. So you can go ahead and say what you want, but I'm letting you know the perspective I'm coming from.
No disrespect to Mr. Brown.
Well, you're about to then. Go ahead.
Yeah, that's exactly what I'm saying.
Really?
That I don't understand.
Okay, you not understanding doesn't mean that the attorney isn't doing their job. I don't see a basis upon which to take Mr. Brown off this case. Now, if you want to hire your own attorney, you can go ahead and hire your own attorney.
Okay, that'll be the next procedure that I'll try to do then.
So you're going to try to hire your attorney. How much time you need to do that?
I'm not sure, sir. I don't know.
Well, I got to set a date. How much time you need? You don't like the best that Washington County may have to offer, and now you want to hire somebody else. How much time do you need?
Well, first of all, I gotta try to come up with some money.
Oh,
Okay. Then second of all, I have to have someone to help me find an attorney.
mm-hmm.
Is it a such thing as a promo attorney?
A what?
I may not be pronouncing that correctly, but I'm a lot of dental work done.
Pro bono.
Pro bono attorney, yes.
A pro bono attorney,
Yes. A pro
meaning
bono.
one that is a good attorney that you're not paying for?
Yeah, yeah.
That's what you want?
Basically, that's what I'm saying. Yes.
Okay, so you realize standing next to you is one of the best that you're not paying for right now. Yeah, I know.
I wouldn't.
I'm shocked.
I wouldn't challenge that. I wouldn't challenge that.
You would?
I wouldn't challenge. I said, I'm not saying he's not. I'm just saying.
Oh, so now you're not saying he's not.
I've said what I've said.
Mm-hmm.
And
So to the extent that is even a proper motion to permit withdrawal of the public defender's office and Mr. Brown, that motion's denied. I don't see a basis upon which to do it.
So, Your Honor, what I'm going to ask to do is to adjourn this for 1 week. So that,
1 week?
yeah, so that my client and I can have a chance to talk and find out the nature of his discontent.
Probable cause conference will be adjourned. 1 week has what, the 6th? June 6th, 2024. 9 a.m. as your invite indicates, bond will continue. All right, Mr. Edwards, I'm going to make a suggestion to you before you take those off.
beg your pardon?
I'm going to make a suggestion to you.
Yes, sir.
Rather than doing a whole lot of thinking yourself, when Mr. Brown comes and talks to you, maybe you ought to listen to him. And then if you have questions and you may not understand something he's saying, you should probably just ask it. And then you'd have probably a better understanding of what's going on, and we don't have to go through this again. Thank you. Have a great day. Court calls the case People versus Victor Hayes.
And Matthew Mansour, Assistant Public Defender Judge, on behalf of Mr. Hayes.
Good morning, sir.
Thank you. Your Honor, we were here last week. I put a waiver form into the file. I'm hoping it's still there. We're still hoping to waive matters up to Circuit Court for further resolution.
Is that what you want to do, Mr. Hayes? You understand that preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand that hearing will not happen and you'll proceed to Circuit Court for further resolution. We'll also waive the right. Preliminary examination having been waived, defendant is bound over to Circuit Court on the single count. Mr. Mansour.
Your Honor, we acknowledge that information, waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
June 13th at 1:30 before Judge Slate Thursday.
June 13th, 2024, 1:30, Slade Thursday.
Thank you, Your Honor. And Mr. Hayes would like me to address bond on his behalf.
Go ahead.
Thanks, Your Honor. We were here last week on a bond violation. Mr. Hayes is just asking for one chance to prove that will never, ever happen again. He will do anything to get that opportunity. He is visibly in a lot of pain right now due to him not being able to take his daily medicines that he's being prescribed to. He wants the court to know that he does have a prostate exam scheduled for June 1st, this Saturday at 6:30 at St. Joe's Hospital. He's spent this long holiday weekend in Washtenaw County Jail the last 7 days. It was a big time reality check for Mr. Hayes. I believe he's had enough time to reflect and realize what is expected of him going forward. And he wants you to know that he promises this will happen again. So we are asking this honorable court if it would consider reinstating Mr. Hayes's bond.
Any response from the people?
And I do just want to know that last week was not the defendant's first violation. We do have a history of him missing tests that go back quite a ways in this case. So I will ultimately leave it in the court's discretion, but this is not the first issue with compliance that we have seen.
That's true. And that's why I took the measures that I took, and ultimately it ended up in him consuming alcohol. And I'll just say I wasn't thoroughly convinced by the story that he gave the court regarding the consumption of alcohol. At this time, I'm going to deny the defendant's motion to reinstate his previous bond. You can take it up with just by bond. We'll continue. Court calls the case, People versus James Moody. Mr. Feaster thinks he did something.
Matthew Manson, Assistant Public Defender, with and on behalf of Mr. James Moody. James, can you state your name for the judge?
James Moody. Thank you.
Thank you, Your Honor. We would like to request a preliminary exam.
Discovery is complete.
My knowledge, yes.
Your Honor, I do know that the 911 calls were requested yesterday in this case. We do not have them yet. Additionally, I did notice that there is on the case ending in 5713, there are videos in evidence.com, but a media notice was not created until this morning. So that has just been, it should have just been released or is being released currently to defense. So on one of the two cases, I do not believe that they have reviewed the videos yet. Or had an opportunity to review the videos yet.
I'm sorry, Ms. Barroso, can you?
So there's
She wasn't speaking French.
there's
She's telling you that you don't have the discovery.
Your Honor, from my knowledge, we do have the discovery.
There's two cases. There's one ending in 5708. There is a media notice that already exists on that case. There is no 911 call in my possession, so it cannot be in your possession yet. I made the request for that yesterday. As of the case ending in 5713, additionally, I also do not have the 911 call in that case. So that means that you do not have the 911 call in that case. I do know that there are videos in evidence.com, but a media notice was not made in that case, so they could not have been released to you yet. So you do not have the videos in the second case.
Okay.
That media notice has been created. It has been added to a discovery packet and should be released to you if it has not already been released to you, but I do not believe that in the last 2 hours, you would have had an opportunity to have reviewed that with your client, unless I'm mistaken.
Correct, Your Honor. And if that is the case, then I'm just going to request a 1-week adjournment to be able to review that, and we can go forward with this.
Probably could have done that about an hour. Okay, sir, I'm going to adjourn your matter out 1 week so they can make sure all the discovery gets to you and that you have a chance to see it. It'll be assessed. So June 6th, 2024, 9 a.m.
Your Honor, I do need to address.
Oh, boy. Go ahead. No, go ahead.
So the defendant was arraigned on May 19th. Prior to arraignment, he made 2 calls directly to the victim's phone number. After that, made an additional 39 calls to the victim's phone number directly. Additionally, to the 39 calls directly to her phone number, he had her change her phone number, and he made additional calls to a new phone number that were also to the victim. I have not tallied up the additional calls beyond the 39 that were directly to her, but at this time, I know that there are above 40 or more that happened after arraignment.
The victim is the same in both of these cases. I have not had an opportunity to listen to those calls. I did disclose that to Mr. Mansour prior to us coming on the record, but I have not had an opportunity to request for them to be released again. I will do so immediately following the hearing.
Any response?
Your Honor, no response. Response. I did not have a chance to look or go over those calls, so.
Right, but irrespective of going over them, the content is irrelevant if he's contacting me.
That's right, Your Honor.
Defendant's bond will continue as it's said. His phone privileges are hereby ordered revoked. Case People versus Lamar Parker.
Andrew, there's a claim on behalf of the people. Good morning, Your Honor. Michael Cobb, P78658. Appearing on behalf of Attorney Allison Fomar for Mr. Lamar Parker. Mr. Parker, would you state your name for the record, please?
Lamar Antonio Parker.
May it please, most honorable court, good morning.
All right, what are we doing? Counsel, did a substitution come in? I'm gonna need a substitution from you. I got an appearance. I'll let you go ahead, but I'll need a substitute.
Correct, Your Honor. I believe that's being prepared. I'll let the attorney of record know. Your Honor, today's date and time set for a PCC. We've been recently retained. It's my understanding that the prosecution is still collecting the discovery. I don't believe the discovery's been complete on the people side as of yet. So I believe we'll need an adjournment. We'll be seeking a lengthy adjournment just because there's some significant legwork to be done. My client, he sustained significant and critical injuries during the same transaction of events from which he was charged. I believe he was offered to press charges himself because of the injuries he sustained. And we'd be seeking to have him give a statement regarding the charges that he's seeking against members present at the time. Additionally, Your Honor, because of the injuries that he sustained and a heart condition that he had previous to this incident, he requires some medical treatment. It's my understanding he's not receiving that. He's on, I believe it's 23-1, he stated. And so he's not receiving any medical treatment for his heart condition or the injury sustained during the event, Your Honor.
With respect to the discovery on this, there isn't quite a bit of discovery in this case. I have seen reports come through as well as media notices about body cams, things of that nature. Those, as we're getting them, are being sent out, but I know I haven't seen an autopsy protocol yet, and things of that nature. These things take time, and as I'm sure the court's aware, the county had 4 homicides in about a 6-day span, so there's a lot of work going on. I'm getting that. The second I get it, it's getting turned over. I have no objection to adjournment for those purposes. Regarding potentially interviewing Mr. Parker, there was basically after the murder took place, there were a number of individuals present and some assaults were committed against Mr. Parker after the shooting took place. He will have an opportunity if he wishes to make a statement to the police. I can coordinate that, of course, through the officer in charge. That's not an issue.
Okay. So how much time out are we going to need?
I don't know what Ms. Fulmer's schedule is looking like, but I would think I would be looking at either the 20th or the 27th for an adjourned PCC, at least so we can kind of keep on top of things.
I have Attorney Fulmer's calendar. She was looking for possibly a little lengthier adjournment. I can make myself available if the court isn't.
Probably like, yeah, sure, you can come back. Well, why don't we do the 20? Why don't we do this? Let's start with the 27th. Let's make sure everything's on track, discovery wise, and everything that it's getting to you. And then if there needs to be a further adjournment, certainly the court can accommodate that.
For the 27th, I know the 20th, her schedule is actually a little bit more open than the 20th.
I have, so counsel, just so you know, I have the 20th, 27th, and July 2nd. I have. So immediately right around that time.
With the July 2nd, does it have to be on a Thursday, Your Honor? Because that's the
July 2nd is a Tuesday.
Okay.
Because I don't plan on being here July 4th.
I
I mean, I will if you want me to come down, but I really don't want to.
I think it might be safest to try for the 20th or the 27th, Your Honor.
All right, that'd be safer for you, you think? Okay, then let me do that. Probable cause conference will be during June 27th, 2024. Mary McGam. Bond will continue, I believe, as denied in this matter. With regard to any type of medical issue, the court typically does not get involved with that. You'll have to talk to the Washington County Sheriff's Office if there's something you believe that he is not doing or medical treatment. I'm not a doctor, so I don't get involved unless it gets to a certain point. They have medical staff there. If he needs to see medical staff, certainly he can request that.
Thank you, Your Honor.
Case People versus Dolores Strickland.
Good morning, Your Honor. Marie Pamela, Assistant Prosecuting Attorney.
Good, so, oh, he's not ready yet. No, got it? Okay.
So Assistant Public Defender with and on behalf of Ms. Strickland. All right, Dolores, can you state your name for the judge?
Dolores Strickland.
Thank you, Your Honor. I was just going to request a adjournment to continue plea negotiations.
Your Honor, just on some background, I don't object to the adjournment. There are a few matters that we should discuss, and I'm not sure about this morning. I received an email pretty late yesterday, saw this morning, indicating to me, it was from an intern indicating that Ms. Strickland has been contacting the victim in the case, at least 2 contacts that we know of. There was also a conversation with her brother, which I'm not so much worried about that contact, but I do want to clarify a few things. So regarding the contact with the victim, of course, that's a violation for bond. I don't have a problem setting it for hearing if we need to. I would ask that her phone privileges be revoked, other than, of course, calling her attorney in their office. Regarding the contact with her brother, as far as I know, there's no condition preventing her from doing so. There are some things that concern me about that contact, including statements by Ms. Strickland that she thinks we're out to get her. She spoke about the prosecutor. I don't know if she was referring to myself or Ms. Willenbrink, doesn't really matter. Very derogatory terms. Again, we're not offended by that. We get that all the time. However, I want to make sure she's clear that none of this is anyone trying to get her. We don't get any prizes, rewards, any more money. There is no benefit in us going after anyone. What we are passionate about is protecting victims of crime. That includes her children, who are deathly afraid of her, who are scared their mother is going to kill them. So her continuing to show up at residence, her being in contact with their father, no matter what the background is. And I will say, the social worker did an excellent job from the PD's office. I didn't review the mitigation report. Officer has done an excellent job of representing Ms. Strickland. Him and I had a conversation about eventually treatment that might be helpful to her. She has trauma in her background. There are specific services. I even sent him a link to a program that I've known the director of, have worked with the director of that program, and I think will be very helpful for Ms. Strickland. At this point, though, the first thing we need to do is get her to follow the orders of this court, because they're in place to protect children, her children, and that's what she should be worried about. So with all of that, no objection to the adjournment. We are trying to work this through. There are no offers at this point. The first thing we need her to do is start following this court's orders, and then we can have a conversation.
Thank you, Your Honor. We have no response to these allegations. We would like to set it for a hearing.
And for the record also, Your Honor, I apologize. I just received the 2 calls made to the victim. My understanding is it involves a debit card or credit card of some sort that belongs to the victim of the case. I haven't had a chance to listen to the calls. I just received them. I will forward those to Mr. Mansour.
Thank you.
So you want a hearing on the phone issue?
Yes, please, Your Honor.
And how long an adjournment did you want?
3 weeks.
Pardon?
3 weeks.
3 weeks?
Yes.
Do you
Oh,
want the
for
hearing
probable,
before that, or do you want?
for the probable cause, Your Honor, I leave that to the court's discretion. The hearing as well.
Well, thank you. So here's what I'll do, because I don't. Probable cause conference as well as a hearing on her bond violation will be set for June 13th, 2024. That'd be at, you want me to do 2 or 3?
Let's do 3.
At 3 p.m. So the probable cause conference will be adjourned to the 3 p.m. time. Your hearing will also be adjourned to that time.
Okay.
In the interim, her bond will continue, however, pending that hearing, defendant's phone privileges are hereby ordered revoked.
You can still contact the attorney, us. Through
If
that.
she wants to, sure. I mean, yes, she can contact her.
Thank you.
Hold on, let me see that.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Glover. Mr. Glover, will you approach the podium and state your name for the record?
Thank you.
Your Honor, I am asking the court to, for a 1-week adjournment. The reason for the 1-week adjournment is we did not receive discovery on this case until late yesterday. And I need an opportunity to receive the 911 calls as well before setting this matter for a preliminary exam.
Are the 911 calls going to get to them within a week?
Yes, Your Honor.
Probable cause conference will be June 6th,
Thank you, Your Honor.
2024, 9 a.m. Bond continues. First case, People versus Bryant Hargrove.
No, focus on behalf of the people. Ms. Apple.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Hargrove. Please state your name for the record.
Bryant Hargrove. Thank you.
Your Honor, if we could have a 2 to 3 week adjournment on this matter, Mr. Hargrove did provide me some documentation today regarding some.
Today?
What was that?
Today?
Yes, he came with it in hand. Some proof of treatment that he's completed. I'd like to provide that to the prosecution.
We didn't have it before. Never mind. Just messing with us. Probable cause conference, June 13th,
Thank-
2024. And a bond continued. Thank you, sir. Court calls case of the People versus Tyler Harlow. Harlow.
Good morning.
excuse me.
Good morning, Your Honor.
Your children's appearing on behalf of people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Harlow. Mr. Harlow, can you state your name, please?
Tyler Harlow.
Your Honor, we're requesting an adjournment. We have not received discovery on this file yet.
I put that today.
I'm sorry?
Never mind. June 13th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Donald, is it Grandal?
Assistant Prosecuting Attorney Morgan Burrows on behalf of the people.
Assistant Public Defender Natalie Pate for Mr. Grandal, who is approaching. Your name for the record, sir?
Donald Howard Randall II.
Thank you, Your Honor. We are respectfully requesting a 1-week adjournment of the probable cause conference. We do not have any discovery yet as of 8:30 this morning. Our office did request it back on the 18th of this month. It is Mr. Grandal's intention to set this for exam, but we would request 1 week so we can receive and review discovery with him.
Is there a problem with discovery? I'm getting a lot of that today, and that hasn't been an issue before. What happened?
Your Honor, it appears that the charging APA did not make a discovery packet in this case. I'm making one right now. It should be released today.
So is that what I'm seeing on a number of these cases where there has been discovery, there wasn't a packet created to get to counsel?
I do just want to state, it's not an issue with our legal assistants or our discovery specialists. They are still doing a very timely job.
Oh, no, I realize you're throwing somebody under the bus, but it's not them. Probable cause conference will be adjourned 1 week out to the 6th, June 6th, 2024, 9 a.m. Bond continued. Court does call the case People versus Iad Ubeles. Before he comes all the way up, has he signed an advice of rights for him?
Assistant Public Defender. Miss. Did you do the advice of rights or is that what's in your hand?
We have not done the advice of rights, but we did.
I apologize. I could answer that. I'm so sorry.
That's okay. That's okay.
Nicole, please on behalf of the people. We are.
They are so nice to each other. They really are.
Well, I forgot. I'm sorry. We're both requesting an adjournment and I will leave the offer open.
Oh, so you don't want me to do this? You need an adjournment.
That is correct. It's Hughes just got the restitution amount today, and so that's some of.
So you have to, okay.
To discuss with my.
Probable cause conference, June 13th, 2024, 9 a.m. Bond continued. Court calls the case People versus Bilal Howard.
Somewhat ready. Torshell Feaster, Assistant Public Defender, appearing on.
If you talk slower, you think they're gonna show or what? You just,
I
you're-
did receive a text message from my client when I saw he was.
you always are getting text messages from your
did.
client. Well, what this one say?
Let me pull it out, Judge.
All right.
I text Mr. Howard at 9:27. And I said, I don't see you in the courtroom. Are you here? At 9:44, he responded, I'm on the way. At 9:56, I said, you close? Question mark. At 10 o'clock, he said, yes, 15 minutes. Have they called me? At 10:05, I said, nope, not yet. So
At 10,
so
where was he coming from?
I have
Ipsy.
no clue. Yeah, I have no clue, Judge. I tried to get him here, Judge. I don't know why he's not present. I'd ask you to pass it, but I don't know. Tried.
Let me ask you this.
Yes, sir.
If I pass it and he doesn't show, can I issue a bench warrant and then get my choice of any PD I want to lock up? I just want to see how much you like that.
If you would excluded me from that list, I might go for that.
Oh, that is so Feaster. It's all about me. Mr. Feaster, I'll pass the matter. Let's see if he shows up.
Thank you.
And then I'll decide who's gonna go. Court calls the case of the people versus DeAndre Jemison. I texted him, you close?
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
DeAndre Jemison.
Thank you.
This matter is before the court today for probable cause conference. I do have discovery.
Okay.
Waiving exams.
All right. Sir, is that correct? You're gonna waive your right to a preliminary examination? He's trying to get that to me. Is that correct?
Yeah, sure.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense is alleged or the offense alleged was committed and that she committed them.
Yeah, sure.
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yeah, sure.
People also waive their right.
Yes, Your Honor, thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2, 3, and 4 following.
Your Honor, we acknowledge receipt of a, excuse me. We acknowledge receipt of a copy of the information in this matter. My client stands mute, asked that a not guilty plea be entered.
Defendant, every way form of reading, standing mute, court will enter not guilty plea as to all counts. I messed up. Pretrial in this matter will be set for
June 11th at 1:30 before Judge Punky.
June 11, 2024, 1:30. Bond will continue. House case, people versus Ryan Howell.
Michigan Opera for the people.
Mr. Feaster's case, but he's out looking for his client.
Follow call.
Yeah, I bet.
Torshell Feaster, Assistant Public Defender on behalf of Mr. Howell, right? Please state your name for the record, sir.
Ryan Howell. Thank you.
Thank you, Judge. This is the first PCC in this matter, I believe. I have spoken to Mr. Howell and to the people on this matter. Mr. Howell is requesting we do a 4-week adjournment. He has some work obligations that are kind of going on right now, which have made some difficulties for him financially. And I need to also talk to Mr. Contra to see if there's a possible way we can resolve this matter. So I figure come back and if the court grants us 4 weeks, hopefully resolved and he can have his work situation cleared up.
I guess I don't understand the work issue.
He was telling me basically that his job is in some kind of a peak situation right now, and he's missed 2 days of work over the last couple of weeks, and he's at risk of losing his employment. So if we can go out.
What's his employment?
I'm a union carpenter, sir. We pour concrete every day at a job. So right now, we're 2 weeks out of any day off. So if you don't have a day off, you're taking a write-up, and they will not have to push you out.
Okay, that's all I need.
Okay.
I just
He
trying
can
to
say it
figure-
better than me, Judge.
What?
He can say it much better than I can.
Oh, he did.
Yes, he did.
Okay. All right. So you need 4 weeks out. Any objection from the people?
No, you're
Probable cause conference. Since it's 5 days between 4 weeks out, I'm gonna do July 2nd. Hopefully, it won't get into any overtime where you get more money, but July 2nd, 2024, 9 a.m.
Thank you so much, Judge.
Not a problem. Bond continue. Thank you, sir. I did that for him because he works hard. Right. It was a contrast with you and him up here with that whole working thing. Court calls the case, People versus Sean Jenkins.
Sam Bernstein for Mr. Jenkins. Mr. Feaster is a very hard worker, Judge.
No, he's not. He really isn't, except on the phone trying to get his plan here.
You say your name, Sean?
Mr. Jenkins. Thank you. Welcome, sir.
Your Honor, we're asking for an adjournment for continued discovery.
You have it, though.
We have
Some
discovery. There's other stuff.
Probable cause, June 13th. Will that be enough time?
Yes, Your Honor. Thank
June
you.
13th, 2024, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case, People versus Hazel Jacobs.
Prosecuting Attorney Morgan Barosa on behalf of the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Jacobs, who stands by my side. Your Honor, can you state your name for the record?
Hazel Jacobs. Thank you.
Your Honor, we were just going to be asking for a short adjournment for further review and to initiate discussions with the prosecutor.
Without objection, June 13th, 2024, 9 a.m. Bond continue. Court calls case, People versus Wheaton Mather.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Mather. Mr. Mather, could you please state your name?
Wheaton Eli Mather.
Okay.
Your Honor, I've spoken with the prosecution recently. It seems like there's some light for making a resolution happen, so I'm asking for the shortest adjournment possible, please.
Probable cause conference, June 13th, 2024, 9 a.m.
Thank you.
Bond will continue.